Good evening to the participants of the JCJ 2022, the main examination, which is going to be conducted on 26 November 2022. And we are continuing the Civil Procedure Code 1998. And here we want to deal the consolidation of the suits or the cases and the effect of the contraventions. And anyone can unmute and read that what I posted on the screen? Participants. Okay, that I myself is read now. So it is me, the Professor Dr. Mohammed Saheb, Professor of Law, School of Laws, and Augustine University of Tanzania, Malimbe, Mwanza, Tanzania, and East Africa. Yes. Now we dealt in the yesterday class of the two kinds of the Yes, according to the Indian Evidence Act 1872, matter and issue are of the two kinds that we explained. Number one, matter directly and substantially in issue. Here, directly means immediately without any intervention. The word substantially implies essentially or materially. The matter collaterally and incidentally in issue, it is just contrary to the matter directly and substantial in issue. So direct issue and substantial issue, where direct means direct interference would be there, and these are the two kinds we studied in the last class. And in this class that we would like to deal, where the parties in suit are the same. If the parties to the same suit are the same, what would be the position here? So let us see that the two suits should be have the same parties are their representatives, and the two suits should have the same parties are their representatives. Other parties may be the same or their representative would be there at that instance where the title of the suit is the same. Even the title of the suit is the same. The title of both the suits for which the parties are litigating should also be the same. When the parties are the same, suit for the title of the suit is the same, or the parties' representatives are the same. At that instance, we can say that yes, at that time we can say parties in the suits are the same. Where the suit must be pending, the former suit must be pending in the court while the later suit is instituted. The word pending is for the previously instituted suit, whether the final decision has been arrived at. If the final decision will not be arrived at, we can say that the suit is pending. Then we can say what is an incompetent court. Section 10 also specifies that a former suit must be pending before a court which is competent to carry out the trial. If the former suit is pending before an incompetent court, no legal effect can flow from it. So if it is incompetent court, it is pending over there, then the idea of the sub judice will not work over there. Illustration, let us see it. X and Y decide to enter into a contract for the sale of a machine. Here the X is one party and the Y is one party. They decided to enter into a contract for what? For the sale of a machine. So X is the seller and Y is the purchaser. Is it clear, Munira?
Yes, sir.
Good. Then
Yes,
Y
sir.
defaulted in paying the amount of this sale to X. So here defaulted a person means the purchaser is defaulted in paying the amount of the sale to X. X first filed a suit for recovery of the entire amount in the Bangalore. So X filed a case for the recovery of the amount from the Bangalore. Then who is X and who is Y?
Who is
Participants.
entered into contract, sir? Who is entered into contract, sir?
Who is X and who is Y?
Those are entered into contracts are parties to suit.
Clearly say X is the seller, Y is the purchaser.
Okay, sir.
Then who defaulted?
Why defaulted, sir?
Y defaulted in the paying the amount of the sale to X. X first filed a suit for the recovery of the entire amount in Bangalore. That means the machine in the position of whom?
X, sir.
X already given it, but Y is defaulted.
Why, sir?
The machine is with the position of Y.
Why,
And the amount did not received by the X. So what the X did it? X has first filed a suit for the recovery of the entire amount in the Bangalore. Subsequent to this, later on, X filed another suit at Bombay High Court demanding 20,000 as outstanding balance. That means how many cases are filed?
2, sir.
Where?
First, he was filed in Bangalore, and then subsequently, he was filed in Bombay High Court, sir,
For the what?
for the balance amount, sir.
How much?
20,000.
Good, good. So in X suit, why took the defense that X suit should be stayed since both the suits are on the similar issue? Issue are the same.
Yes,
And
sir. Yes,
however,
sir.
the Bombay court held that since the X first suit and the second suit have similar issues, similar to the first issue, first suit, the subsequent suit is liable to be stayed.
Stayed.
So that will be stayed over there. The first will be commenced as usual. Why a person will file a suit in the both the places?
It's to bother the defendant, sir.
To harass the?
To harass the defendant.
Yes, and wasting the time of the two courts for the same
Yes,
issue
sir.
or the same
Yes,
cause
sir.
of action. So he might have shown that the jurisdiction of the Bangalore because he said that he sold the machine at the Bangalore. But he has filed in the Bombay because it is his residence house. That was the reason that he has shown that that's why the Bombay court has made the jurisdiction to entertain such a case. But later on they found it the case also filed in the Bangalore. Then the Bombay court suit is stayed. So that is an example over there. P was an agent in Patna who agreed to sell goods in Odisha to M. P, the agent, can file a suit for the balance amount in Patna. M sues the agent P for account on his negligence in Odisha. While the case was pending in Patna, in this case, Patna court is precluded from the conducting the trial and can petition, yes, pending in Patna. In this case, Patna court is precluded from conducting the trial and can petition Odisha court to direct a stay of the proceeding in Patna court. So generally stay would be given where?
To stop the suit, sir, for further proceedings.
Is the first one where the filed or the second one filed?
Yes, sir.
Where? First one or the second one?
Second one, sir.
So M sues the agent P for the account in his negligence in Odisha while the case was pending in Patna. Means first filed a case in Patna. That's why you say case is pending in Patna. In this case, Patna court is precluded from the conducting the trial and can petition Odisha court to direct a stay of proceeding in Patna court. So now it is depend which court is having a jurisdiction to entertain such a case, and that depends upon which court to be stayed over there, and that would be done in this example. So in the above example, they say first one is stayed, but the second one, if you happen to see, is the first one is stayed. Is it true? Or the second one is stayed?
Second one has to be stayed, sir.
Precluded means removed from conducting a trial. Is it not?
Yes, sir. Yes, sir. Why this case, sir?
Yes, yes. Precluded means removed. That gives a sense that the person who filed a case in the beginning would run, and the second one is precluded. Is it clear?
Okay, okay, sir.
Okay, the moment the above conditions are satisfied, a court cannot proceed with the subsequently instituted suit. See, subsequently means second suit. Am I right?
Yes, sir. Yes, sir.
Since the provisions contained in the section 10 are mandatory and the court cannot exercise its discretion, the order of stay can be made at any stage of the proceeding. So a stay can be made any stage of the proceeding, it could be done. So that is about the stay. However, Section 10 takes away the power of the court to examine the merits of the case thoroughly. If the court is satisfied with the fact that subsequent suit can be decided purely on legal point, it is open for the court to decide in such a suit. If it is a legal point would be there, at that instance, it can be conducted. It is open for the court to decide in such a suit. So it is the court will make such a decision either to preclude it or to conduct it. Is it clear?
Okay, sir. Clear, sir.
Then what is the test? The test of the applicability of the Section 10 is whether the decision in a former given suit would operate as a res judicata, that is a decided cases. In the subsequent suit, two suits are there. In the first suit, it is decided, and that would be a precedent or decided cases or a res judicata for the subsequent suit. So it is this happens, then the later is suit must be stayed. Means the later should not be conducted, it will be stayed because first suit the matter is settled. Means case is decided.
Decided.
That means res judicata.
Yes, sir.
Yeah. Welcome, Sir Venunath. But anyway, that you put your promise to see that. And we are discussing which court is having a right to stay when the suit is filed in the two different places. Any your practical experience? Are you hearing me, Venunath? Of course, still.
Yes.
Can a person will file a suit
Yes.
in the two places?
Can a person file suit in two places?
For the same cause of action. And the
No.
places are the same.
No.
The first one will be precluded, the first one will be taken and the second one will be stayed.
Yes.
So that we are discussing now. Section 10. This also can be inferred from the SPA Annamalai Chetty versus BA Thornbill suit pending. That is observed it. A person cannot file a suit in the two places. In case if he filed it, the first one holds good, the second suit will be stayed. Is it clear?
Yes.
A suit pending in a foreign court. Suppose a suit pending in a foreign court, what is the rule position in India? The explanation clause of Section 10 clearly provides that there is no limitation on the power of an Indian court to try a subsequent instituted suit if the previously instituted suit is pending in a foreign suit.
Country.
This also means that the cases can be carried on simultaneously in two courts because two courts are different in countries. Is it clear?
Yeah.
At that instance, one country cannot make such an instructions to another country to stay. The reason is each country is a sovereign country. So what is the inherent power to stay? The word inherent, yes. The word inherent has very wide meaning which includes an inseparable part of something or an attribute or the quality which is permanent and essential. So that is the inherent thing. It is something which is intrinsic and attached to a person or an object. Therefore, inherent powers are the powers of the court which are inalienable. That is EIE. What is meant by IE?
That is.
What is the Latin terminology? Id est.
Means.
Id est. 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 So something which can be separated or taken away from the court and they exercise in order to provide a complete justice to the parties.
Which courts have inherent powers in India?
High Court is an inherent power. I believe the Supreme Court is also inherent power. I don't know whether
Only
district court is having inherent power.
No, only two courts have
But
inherent
in
powers.
CPC, all courts having
No,
inherent power.
no. All courts don't have inherent powers. Only the High Court and the Supreme Court and the chartered courts have inherent powers.
Okay.
In civil cases, sir,
Subordinate courts don't have inherent powers. They have to follow the act.
Oh, can you give an example?
Example, if a session court wants to give death sentence to anyone,
Okay.
the sessions court cannot give death sentence directly.
Okay.
The sessions court has to give
information.
to the High Court.
Mm-hmm.
But in
Court's
civil
finding. Then
cases,
the High Court. Wait, let
But
me
in-
complete. Let me complete. Then you can
Okay.
talk,
Yeah,
or
yeah,
else
yeah.
I'll keep what you talk.
Okay. Please continue.
The High Court, after finding, then it says, okay, now you can give death sentence. Then the file comes back to the Sessions Court. Then only it can give death sentence. The Session Court
In other words, endorsement of the High Court is must.
is a must for death sentence. Sessions courts have no jurisdiction to give that.
Okay,
When
Munira,
High
you
Court-
want to add something? Munira,
Sir,
do you want to add something because you are saying some civil court?
nothing, sir. But I am telling about 151 of CPC, sir. Here, inherent powers to any court, sir. So, any court can exercise inherent power, sir.
And that means
CPC.
any court means including the session court and the sub court, even a municipal magistrate court also.
Yes, sir. Regarding to CPC, sir. But
one thing, if there are inherent powers given to all the courts, why the chief judicial magistrate or first class judicial magistrate don't squash FIRs? Why it has to go to High Court only?
Sir, please, I am just telling about civil
Yeah.
cases.
I think the civil matters like that.
No civil. When it comes to inherent powers, there is no difference between civil cases and criminal cases.
Okay.
Powers remain the
There
same.
inherent powers of High Court in 482 sections, sir. But in civil cases, if 151 for civil, sir.
With the civil practice rules,
They already mentioned that 482 section of CRPC that High Court have inherent powers in CRPC, sir. But in civil cases, they regard every court can exercise inherent powers.
does
sir.
it
So
depends
everyone
upon
court-
state to state?
Yes, sir.
No.
Sir,
I'll tell
no,
you.
sir, all.
Subordinate
So
courts
that's why,
have.
sir, we have here we have first class magistrates, sir. In civil cases, we are always filing for delay petitions. Always we have 151 sections, sir, petitions for delay or anything excuse for inherent powers of that court, sir, to exercise
Okay.
Those are
Anyway,
not called inherent powers. Those are called ancillary powers.
Okay.
There is a difference between ancillary powers are different. Inherent powers. Inherent powers are those powers which were acquired by birth. High courts and Supreme Courts are the only two courts in India which are constitutional courts. Only these two constitutional courts have inherent powers. Rest all are subordinate courts which are constituted by the state governments. So they don't have inherent powers. They have ancillary powers.
Okay, sir.
So can you see the section 151 of the CPC? Whether it says the same thing? Yes, I open it and Control F. 150. What do you say? Section
151 of CPC, sir.
151. Let us check it. Saving of inherent power of a court. Let me go directly. Saving of inherent powers of a court. Nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of the court. So, in the interest of the justice as well as prevent the abuse of the process of the court, even every court is having some inherent powers.
Those are actually it is called ancillary powers. Only constitutional courts have inherent powers.
But
I don't want to debate
here
on that.
said is inherent powers of a court. So
But these are
Okay, anyway,
No,
let us see that because inherent powers are different from ancillary powers.
yes.
Okay, let us see that how it can be power. But as far my knowledge goes, all the code doesn't have the inherent powers. That's the general saying is concerned. But anyway,
Because
let us make it a debate later on this aspect.
why this section is referred.
Okay, okay.
Why this section is referred? This is they that to end the justice. मतलब आपको फैसला लेने में easy करने के लिए inherent powers दिया, but you cannot interpret the constitutional laws, or you cannot interpret the act as the way you want, how the Supreme Court and High Court does.
Okay, but now here it is given in the next para. Even where the provision of section 10 don't strictly apply, a civil court has inherent power under section 151 to stay a suit to achieve the justice. So, to achieve the justice, number one, and the practice of the following is deviated, at the time, believe that at the time the court will interfere in that matter. Let us see that additionally courts can also consolidate different suits between the same parties in which the matter of issue is substantially the same. Of course, the matter is substantially the same and the parties are the same. Naturally, res judicata will be applicable, number one. Number two, the second subsequent filing will be stayed. Okay?
Yeah,
Okay,
yeah, yeah.
sir.
Let us make it out time being. So next in Bokaro and Ramgarh Limited versus State of Bihar and another, it is a 1962 case. The matter in issue was regarding the ownership of the property. Okay, the court in this case used its power and consolidated the different issues having the same matters. At that instance, we can say they have the inherent power, it seems, because when they consolidate the different issues having the same matter, so consolidation of the suit means if the same matter would be decided, a same matter will be raised in the court, all the matter will be consolidated by the High Court or the Supreme Court, and they give the decision. At that instance, whatever the cases are still in the pending in the different courts, that will be decided as decided by the Supreme Court. Am I right?
Yes, sir.
For the same cause of action, different high courts suits are filed. And Supreme Court consolidated all the things. Of course, they approached it. Instead of approaching it, if everybody file the same suit in the Supreme Court, can the Supreme Court consolidate all the suits and make it one declaration, one decision? Because I read in somewhere, there are different writs are there, and all put consolidated and give the judgment. And the judgment given is applicable to all the writs which are pending or which are filed by the court, by the parties to the competent court. Okay, consolidation of the suits. The objective behind the section 10 is to avoid two contradictory decisions in the same matter by different courts. To overcome this, the court can pass an order of consolidation of both the suits. In the case of Anurag and Company and others versus Additional District Judge and others, it was explained that the consolidation of suits is ordered under section 151 of the meeting the ends of justice, and it saves the party from the multiplicity of the cases, delays and expenses. The parties are also be relieved from the producing the same evidence at the two different places. At that instant, the consolidation could be passed, could be made, and the judgment which passed over there is applicable to all the cases which are filed in a particular court. So, effect of contravention. Any decree passed in contravention of the section 10 is not null and void, null, and therefore cannot be disregarded completely. It is to be clearly understood here that it is only the trial and not the institution of the subsequent suit which is barred under this section. But this right which is in favor of parties can be waived by them. Hence, if the parties in a suit decides to waive their rights and ask the court to proceed with the subsequent suit, they cannot afterwards challenge the validity of the subsequent proceedings. Now the question comes over there. Why the party will file the two cases in the two different places? What is the reason? Do they want that one court will not give the decision in favor of it, at least second court will give it? Is it that idea?
Yes, sir. Yes, sir.
But when you say such an idea would be there, then why the court will stay the second proceedings?
Yes, sir.
Is it not the waste of the time for the same cause of action? And the parties are the same, but only the filing is in different places? Is it not the multiplicity of the cases?
Yes, sir.
So these are all the points should be there where we can throw light. It's interim orders. What is meant by interim orders? Interim orders are the temporary orders which are passed for a limited duration just before the final order. Like interim injunction. Can we say interim injunction or a temporary injunction? What is the
Interior
appropriate
injunction.
word?
It's
Interior orders are given during the proceedings, sir.
Okay. An order of the stay under section 10 does not take away the power of the court to pass interim orders. Okay, they can pass
Yes,
the
sir.
interim orders.
Such subsequent court can pass interim orders, sir.
Okay, subsequent court can pass an interim order.
Yes, sir.
Okay, therefore the court can pass such an interim orders as it thinks fit
For the end of
for
justice.
the like attachment of the property or injunctions in such cases.
Yes, sir.
Excuse me. But same cause of action, same parties, two decisions are contradictory to each other. At that instance,
I didn't get same parties.
same parties, same cause of action, two different jurisdiction, file the case in one court, let me say it is liable, in another court, they say it's not liable.
No, it is like this. You cannot run two proceedings simultaneously. Only one case has to go. But it is the duty of the petitioner to inform the court. If it doesn't inform the court that he has filed subsequent, then the judgment which it will be treated as obtained as fraud.
That means the court can take the suo motu action against the person who filed the case.
Yes.
Okay. Now let us see res judicata. And I believe that which section says about the res judicata? Is it in the civil procedure code or it is in the evidence?
Evidence also is there, sir. Section 40 in civil
What about the
procedure
civil procedure code?
Section 11, sir.
11.
Res means subject matter and judicata means adjudged, means disposed or decided, and together it means a matter adjudged, a matter disposed. In simpler words, the thing has been judged by the court. The issue before the court has already been decided by another court and between the same parties. Hence, the court will dismiss the case as it has been decided by another court. Of course, these two courts are in different states. What is the position?
Res judicata also applies, sir.
Res judicata applies, sir, even in same court or different court.
Suppose a decision given in Maharashtra
and
the case is filed in the Telangana state.
For what? Same matter?
Same matter.
Same parties, same or different?
Of course, parties are different.
Then no, that's different. That is different.
Can you make it the judicata of the Maharashtra in state of Telangana?
No. Both are different. The subject matter, parties, cause of action, nature of relief, everything should be same. Then res judicata applies.
Okay. Then
if parties are different, matters more or less same, prayer clause is more or less same, then it doesn't apply. Res judicata, it's completely different.
A res judicata can be applied both the civil and criminal.
क्रिमिनल तो सर वैसे भी अप्लाई नहीं होता है.
But they say res judicata applies in both the civil and criminal legal
I
system.
know, because once you're convicted, you cannot be convicted for the same offense.
Of course, it
Again,
doubles your body. No suit which has been directly or indirectly tried in a former suit can be tried again.
Yes.
So, res judicata example we have seen, A sued B as he did not pay rent. Okay, B pleaded for the lessening of a rent on the ground that the area of the land was less than the mentioned on the lease. The court found that the area was greater than shown in the lease. The area was excess and the principle of res judicata will not be applied. Means in the rental, the rent capacity will be different from place to place. If a decision is given in a particular area, then the same cannot be used as a res judicata because it depends upon the area where it is rented. Am I right?
Mm-hmm.
Is it the same thing?
Yeah.
Yes, sir.
Now, yesterday we are also a bit confused whether the sub judice or lis pendens both are the same.
No.
No, sir.
Dispendency is a matter which is pending in court.
Okay.
And subjudice is when you tell the court the matter is subsidized, you don't tell it's dispendency. When you argue in front of a court, in front of a judge, you say the matter is subjudice. You don't say it's dispendency.
Okay.
But when you make a petition, then you don't write subjudice. Then you write dispendency.
Okay. Now I got the differences. Huh? Because yesterday we also got it. Both are giving the same sense, but the using is different.
Using is different.
So in a case, a new lawsuit was filed in which the defendant requested the court dismiss the lawsuit with a plea of res judicata. She was barred from bringing a claim of res judicata because her previous claim was dismissed for fraud. The court said the defense of res judicata must be proved by evidence. So if a decision is given on fraud, we cannot use as a res judicata.
Yes, once it is decided.
In places, no, the court itself says it is the obiter dicta, not the ratio decidendi.
Yes, sir.
In the obiter dicta, for the justification to the parties for the same based on the merits, the court has decided, but it is not meant for the precedent. It is not a ratio decidendi. It is a obiter dicta. In particular case only, it is decided over there. So the court may make such a decision also or judgment also. The principle of res judicata. The principle of res judicata seeks to promote the fair administration of justice and honesty and to prevent the law from abuse. The principle of res judicata applies when the litigant attempts to file a subsequent suit on the same matter after having received a judgment in a previous case involving the same parties. So parties should be same. Am I right?
Yes, sir.
So in many jurisdictions, this applies not only to the specific claims, but in the first case, but also to claims that could have been made during the same case. So in such a thing, when once the matter is decided, yes, that will be used as a res judicata and the judgment could be used as a precedent. Is it clear?
Yes, sir.
Now let us see what is the prerequisite for the res judicata. A judicial decision by a proficient court or tribunal, means competent court or tribunal, and is the final and binding, and any decision made on the merits, a fair hearing, earlier decisions, right or wrong, are not relevant. That is the prerequisite for the res judicata. Then we say the nature and scope of res judicata. Res judicata includes two concepts of claim: preclusion and issue of preclusion. The issue of preclusion, also known as collateral estoppel. Parties cannot sue each other again after the final judgment on the basis of the merits have reached a civil litigation. For example, if a plaintiff wins or loses a case against the defendant, in the case, say A, he cannot probably sue the defendant again in the case B based on the same facts and events. So the facts should be the same, the event should be the same, and the party should be the same. Am I right?
Yes, yes. Best thing is that you can go for appeal then.
Suppose if they file in the different courts, the first one is be taken, the second one will be the stayed. Is it not?
Hmm.
So not even
You have been estoppel from doing that.
okay. Of course, estoppel also will come into the picture.
Hmm.
Yeah, not even in a different courts with the same facts and events. See, it is clearly mentioned. Not even a different courts with the same facts and events. Here, different courts mean the different court of the state or different courts of the country.
Yeah. Any court, different court, it doesn't mean within the state or outside the state.
Are you sure?
Yeah. Court means, example, if I'm suing you in Hyderabad, you are from Hyderabad, I am from Mumbai.
Yes.
I can sue you here in Mumbai. But I
Okay.
cannot come and sue you again in Hyderabad.
Okay.
Different state बोल के. Different
Mhm.
state, different jurisdiction बोल के I cannot come and sue. But the matter is same, the cause of action is same, relief is same, everything is same. Then only one court will apply. Either Hyderabad I should file or in Bombay.
But you cannot entertain the your proceedings in two cases. I mean, two places.
Yes. Two places, no. Whether it's in within the state or outside the state.
And it is the forum shopping, can I say? No.
You call it forum shopping, but forum shopping doesn't happen.
Okay. Forum shopping comes, which is the advantage to the plaintiff. There he will file the case.
Yes.
So whereas in issues preclusion, it prohibits the relitigation of the issues of law that have already been determined by the judge as a part of an earlier case. So rejudicata acts like a preclusion, or either issue is concerned or the claim is concerned. Is it not?
Yeah.
The scope has been decided in the case of the Ghulam Abbas versus State of Uttar Pradesh. In this case, the court incorporated the rules as evidence as a plea of an issue already tried in an earlier case. The judgment of this case was difficult as the judge should apply res judicata. It was decided that res judicata is not exhaustive, and even if the matter is not directly covered under the provision of the section, it will be considered as a case of res judicata on general principles. If any new variation or new issues are there, at that instance, I believe the res judicata will not apply. Am I right?
Now, what do you mean by new variations?
Suppose the claim is there, a new thing has emerged over there. Based on the new thing that he filed a case.
Already I filed a case, okay?
Yeah.
Tomorrow some new things will happen.
Yeah.
So I cannot go and file in some other place new case.
Achha. In the same place we can again file?
No, even the same place I cannot file. I have to file an amendment of plea.
Achha, we can ask for the amendment of, okay.
That is Order 6, Rule 17.
So the same court will amend even the judgment also.
No, there is a difference in that. Whenever you make an amendment of petition,
Okay.
application,
छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा चल गणनायक जय भारत भाग्य विधाता जय 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 जय
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।